Hello, everybody, and welcome to History/Law Bite number 332, dated December 20th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in today. This History/Law Bite is entitled Lawrence versus Texas, 539, U.S. 558, 2003. Before I begin, however, I'd like to invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. And in addition to that, please also click on that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. You are the best. So again, this History/Law Bite is entitled Lawrence versus Texas, 2003. Lawrence versus Texas, if you've never heard of this very prominent Supreme Court decision, was a landmark Supreme Court case which ruled that laws criminalizing homosexual sodomy are unconstitutional as they violate the liberty and privacy of consensual adults. So, let's get to the facts of this very important and far-reaching U.S. Supreme Court case. So the facts of this case began in Harris County, Texas, where petitioner John Gardner Lawrence resided at the time. In September 1998, he had allowed two friends, Tyrone Garner and Robert Eubanks, to stay with him as they lacked transportation home. The evening quickly turned sour, however, when Eubanks, who presumed that Lawrence and Garner were flirting with one another, called police asserting a weapons disturbance in the unit. Sheriff's deputies quickly arrived and entered the unlocked unit with their weapons drawn. The first officer to arrive, Joseph Quinn, would later report that he saw Lawrence and Garner engaged in anal sex in the bedroom. The second officer reported that he saw the pair engaged in oral sex, while the remaining two officers reported not seeing the couple engaged in any sexual activities at all. Quinn had the discretion to decide what to charge them with, as he was the first one there. But before deciding to charge them with unlawful sex, he had to get clearance from the local district attorney. The DA informed him that Texas's anti-sodomy statute made it a Class C misdemeanor to engage in deviant sex with an individual of the same sex. This had been adopted in 1973 when Texas decriminalized homosexual anal and oral intercourse. Ultimately, Quinn would arrest Lawrence and Garner, charging them with violating the previously mentioned Texas anti-sodomy statute. After being held in jail overnight, and a hearing the next day, they pleaded not guilty to the homosexual conduct charge. Eubanks would plead no contest to filing a false police report and was sentenced to 30 days confinement, but was ultimately released before his term was up. Lambda Legal, a prominent gay rights advocacy firm, convinced the two men to change their plea from not guilty to no contest. On November 20th, 1998, both men pleaded no contest, waived the trial right, and were fined $100 plus court costs. As the fine amount was not enough to initiate an appeal, the defense attorneys asked the justice of the peace to increase the fine. Accordingly, it was raised to $125. Both the justice of the peace and prosecutors here were well aware that Lambda was attempting to mount a constitutional challenge and went along with it. On appeal, in the Harris County Criminal Court, attorneys for Lawrence and Garner filed motions to dismiss, arguing that the Texas law violated the Equal Protection Clause of the 14th Amendment to the United States Constitution, as it did not restrict heterosexuals, but only homosexual persons. They also argued that the law violated the right to privacy, and that the court's decision in Bowers v. Hardwick, 1986, which refused to extend privacy rights to homosexual persons, was decided in error. Accordingly, the judge denied the motions to dismiss, and both men again pleaded no contest and were fined $200 each, an amount agreed to by both the state and the defense. On appeal to the Texas 14th Court of Appeals, a three-judge panel ruled 2-1 in June of 2000 that the statute violated the Texas Equal Rights Amendment of 1972, which barred discrimination based on sex, race, creed, color, or national origin. On March 15, 2001, after reviewing the case en banc, the Court of Appeals, in a 7-2 decision, reversed the three-judge panel, flat out rejecting the arguments on equal protection and substantive due process. With this defeat, attorneys for the petitioner asked the Texas Court of Criminal Appeals, which is the state's highest court for criminal cases, to review the case. After a whole year's delay, the request would be denied on April 17, 2002, which coincidentally was the day that the author of Bowers, former Supreme Court Justice Byron White, passed away at the age of 85. Back to this, however. Petitioner's attorney then filed a petition for certiorari at the Supreme Court of the United States on July 16, 2002. Accordingly, the Supreme Court accepted the case for cert on December 2, 2002, and heard oral arguments on March 26, 2003. Attorneys for the petitioners, Paul Smith, argued strongly that the law unjustly and discriminatorily interfered with the basic right of consenting homosexual adults to engage in a particular type of sexual act, in this case, sodomy. Heterosexual couples faced no such prohibitions on their sexual abilities. Therefore, the Texas statute violated both the due process and equal protection clauses of the U.S. Constitution. They argued that the court's precedent in Bowers v. Hardwick in 1986 was wrongly decided and was inconsistent with other precedents decided since that time, and therefore should be overruled. Respondent's attorney, Charles Blumenthal, argued that the state had a legitimate interest in preserving the prohibition against homosexual sexual activity. These laws were a reflection of traditional morality and were used as a buttress to defend prohibitions on other actions that were essentially moral in nature. Should these laws be ruled unconstitutional, it would be harder to defend traditional laws against bigamy, polygamy, incest, and other banned sexual marital activities. Okay? The state's interest was also in preserving traditional marital relationships, and the legalization of homosexual activities might erode that foundation, leading to the full-scale legalization of the gay agenda, quote-unquote, under the laws of the state. Keep in mind, this is 2002, 2003, folks, so we, still had a very, very long way to go, all right? So that takes us to the issues. The Supreme Court of the United States was faced with the following three issues in Lawrence versus Texas. Number one, do the criminal convictions of John Lawrence and Tyrone Garner under the Texas homosexual conduct law, which criminalizes sexual intimacy by same-sex couples but not identical behavior by different-sex couples, violate the 14th Amendment guarantee of equal protection of the laws? Number two, do their criminal convictions for adult consensual sexual intimacy in the home violate their vital interests in liberty and privacy protected by the 14th Amendment's Due Process Clause? And number three, should Bowers versus Hardwick, 1986, be overruled? Which then takes us to the opinion of the court. The answer to those questions, accordingly, was no, yes, and yes. On June 26, 2003, the Supreme Court, via Justice Anthony M. Kennedy, gave a 6-3 victory to the petitioners, Lawrence and Gardner. Speaking for himself, as well as Justices John Paul Stevens, David Souter, Ruth Bader Ginsburg, and Stephen Breyer, Kennedy's opinion held that the Texas law criminalizing same-sex conduct violated the Due Process Clause of the 14th Amendment, violating their rights to liberty and privacy for consenting adults. The decision overruled the previous controlling case, Bowers versus Hardwick, 1986, and rejected its premise, denying the extension of constitutional privacy to the sexual relationships of homosexual adults. Justice Sandra Day O'Connor filed an opinion concurring in the judgment, And Justice Antonin Scalia filed a dissenting opinion that was joined by Chief Justice William Rehnquist and Justice Clarence Thomas. Justice Clarence Thomas also filed a separate dissenting opinion in this case. So that takes us to the summary of the opinion. All right, listen up. This is the cheat sheet summary of the opinion of the court here in Lawrence versus Texas. The Texas law, which criminalized the private sexual conduct of homosexual persons, infringing upon their rights to liberty and privacy, violated the Due Process Clause of the 14th Amendment to the U.S. Constitution. The controlling precedent, Bowers v. Hardwick, 1986, was therefore overruled. That's the summary of the opinion. Okay? So Kennedy's majority opinion contained the following points. Number 1, resolution of this case depends on whether petitioners were free as adults to engage in private conduct in the exercise of their liberty under the Due Process Clause. For this inquiry, the court deems it necessary to reconsider its Bowers holding. The Bowers court initially made the substantive statement. The issue presented is whether the federal Constitution confers a fundamental right upon homosexuals to engage in sodomy. Okay? It discloses the court's failure to appreciate the extent of liberty at stake. To say that the issue in Bowers was simply the right to engage in certain sexual conduct demeans the claim that the individual put forward, just as it would demean a married couple were it said that marriage is just about the right to have sexual intercourse. Although the laws involved in Bowers and here purport to do no more than prohibit a particular sexual act, the penalties and purposes have more far-reaching consequences touching upon the most private human conduct, sexual behavior, and in the most private of places, the home. They seek to control a personal relationship that, whether or not entitled to formal recognition in the law, is within the liberty of persons to choose without being punished as criminals. The liberty protected by the Constitution allows homosexual persons the right to choose to enter upon relationships in the confines of their homes and their own private lives, and still retain their dignity as free persons. Number 2, having misapprehended the liberty claim presented to it, the Bowers court stated that prescriptions against sodomy have ancient roots. It should be noted, however, that there is no long-standing history in this country of laws directed at homosexual conduct as a distinct matter. Early American sodomy laws were not directed at homosexuals as such, but instead sought to prohibit non-productive sexual activity, more generally, whether between men and women or men and men. Moreover, early sodomy laws seem not to have been enforced against consenting adults acting in private. Instead, sodomy prosecutions often involve predatory acts against those who could not or did not consent. Relations between men and minor girls or boys, between adults involving force, between adults implicating disparity in status, or between men and animals. The long-standing criminal prohibition on homosexual sodomy upon which Bowers placed such reliance is as consistent with a general condemnation of non-procreative sex as it is with an established tradition of prosecuting acts because of their homosexual character. Far from possessing ancient roots, American laws targeting same-sex couples did not develop until the last third of the 20th century. The Bowers court was, of course, making the broader point that for centuries there have been powerful voices to condemn homosexual conduct as immoral. But this court's obligation is to define the liberty of all, not to mandate its own moral code. Very powerful statement. I'll read that one more time. But this court's obligation is to define the liberty of all, not to mandate its own moral code. Number 3, Bowers' rationale does not withstand careful analysis. In his dissenting opinion in Bowers, Justice Stevens concluded, number 1, the fact that a state's governing majority has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting a practice. And number 2, individual decisions concerning the intimacies of physical relationships, even when not intended to produce offspring, are a form of liberty protected by due process. That analysis should have controlled Bowers, and it controls here. Bowers was not correct when it was decided, is not correct today, and is hereby overruled. This case does not involve minors, persons who might be injured or coerced. those who might not easily refuse consent, or public conduct or prostitution. It does involve two adults who, with full and mutual consent, engaged in sexual practices common to a homosexual lifestyle. Petitioners' right to liberty under the Due Process Clause gives them the full right to engage in private conduct without government intervention. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. I'll read that one more time. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. It is a promise of the Constitution that there is a realm of personal liberty which the government cannot enter. This Texas statute furthers no legitimate state interest which can justify its intrusion into the individual's personal and private life. Okay? So those are major points from Justice Anthony Kennedy's majority opinion. Next, Justice Sandra Day O'Connor filed an opinion concurring in the judgment. She wrote, "The court today overrules Bowers versus Hardwick. I joined Bowers and do not join the court in overruling it. Nevertheless, I agree with the court that the Texas statute banning same-sex sodomy is unconstitutional. Rather than relying on the substantive component of the 14th Amendment's Due Process Clause, as the court does, I base my conclusion on the 14th Amendment's Equal Protection Clause. The Equal Protection Clause of the 14th Amendment is essentially a direction that all persons similarly situated should be treated alike. And the effect of Texas's sodomy law is not just limited to the threat of prosecution or consequence of conviction. Texas's sodomy law brands all homosexuals as criminals, thereby making it more difficult for homosexuals to be treated in the same manner as everyone else. Indeed, Texas itself has previously acknowledged the collateral effects of the law, stipulating in a prior challenge to this action that the law, quote, legally sanctions discrimination against homosexuals in a variety of ways unrelated to the criminal law, end quote, including in the areas of employment, family issues, and housing. A law branding one class of persons as criminals solely based on the state's moral disapproval of that class and the conduct associated with that class runs contrary to the values of the Constitution and the Equal Protection Clause under any standard of review. I therefore concur in the court's judgment that the Texas sodomy law banning deviant sexual intercourse between consenting adults of the same sex, but not between consenting adults of different sexes, is unconstitutional." So Justice Sandra Day O'Connor wrote a powerful concurrence to the majority opinion, whereby she argued, she agreed with the outcome of the decision, but would have reached the same conclusion from a different path. Justice O'Connor would have held the law to be unconstitutional via not the Due Process Clause, but the Equal Protection Clause. Okay, big difference. Kennedy used the Due Process Clause, okay, the substantive component of the Due Process Clause, okay, a fundamental right to liberty, and basic privacy in the home, all right, regardless, okay, of one's sexual orientation. Whereas Justice O'Connor based her belief that it was unconstitutional under the Equal Protection Clause, as the law clearly targeted homosexual persons, in their private sexual activities, but completely left out heterosexual persons and did not harass them and oppress heterosexual persons with this type of law, only homosexual persons. And as these two groups are similarly situated, this constituted, in the eyes of Justice O'Connor, a serious and real violation of the Equal Protection Clause of the 14th Amendment, as it furthered no legitimate state interest for treating homosexuals differently. Okay? So that takes us to Justice Antonin Scalia's dissenting opinion, which was joined by Chief Justice Rehnquist and Justice Clarence Thomas. Justice Scalia wrote, "Liberty finds no refuge in a jurisprudence of doubt," which is a quote from Planned Parenthood of Southeastern Pennsylvania versus Casey, 1992. That was the court's conclusion barely more than a decade ago to those who were seeking to overrule Roe versus Wade. The court's response today to those who have engaged in a 17-year crusade to overrule Bowers v. Hardwick is very different. The need for stability and certainty presents no barrier. Most of the rest today's has no relevance to the actual holding. all right, that the Texas statute furthers no legitimate state interest, which can justify its application to petitioners under rational basis review, right? Though there is discussion of fundamental propositions and fundamental decisions, nowhere does the court's opinion declare that homosexual sodomy is a fundamental right under the Due Process Clause, nor does it subject the Texas law to the standard of review that would be appropriate, strict scrutiny, if homosexual sodomy were a fundamental right. Let me be clear that I have nothing against homosexuals or any other group promoting their agenda through normal democratic means. Social perceptions of sexual and other morality change over time, and every group has the right to persuade its fellow citizens that its view of such matters is the best. That homosexuals have achieved some success in that enterprise is attested to by the fact that Texas is one of the few remaining states that criminalize private consensual homosexual acts. But persuading one's fellow citizens is one thing, and imposing one's views in absence of a democratic majority is something else. I would no more require a state to criminalize homosexual acts, or, for that matter, display any moral disappropriation of them, than I would forbid it to do so. Okay? What Texas has chosen to do is well within the range of traditional democratic action, and its hand should not be stayed through the intervention of a brand new constitutional right by a court that is impatient of democratic change. It is indeed true that later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. And when that happens, later generations can repeal those laws. But it is the premise of our system that those judgments are to be made by the people and not imposed by a governing caste that knows best. One of the benefits of leaving regulation of this matter to the people rather than to the courts is that the people, unlike judges, need not carry things to their logical conclusion. So Justice Scalia is making an argument in his dissent that, quite frankly, he didn't have anything against didn't have anything against homosexual persons. The law might not have been to his taste, or he might, he would, according to this, he wouldn't have supported it, nor necessarily been against it. But the bottom line was the fact that it was up to the people of Texas to change this law, not the Supreme Court. That the law should have been modified by way of the normal democratic process, all right, not through judicial fiat. That is his issue. That was always his issue when he felt the Supreme Court was taking away the right of the people to make decisions which he felt were best left in the hands of the democratic process. Okay, so that takes us last to Justice Clarence Thomas's dissenting opinion that, almost, seemed to be near sympathetic to the petitioners in this case, in spite of it being a dissent from the majority opinion. Justice Thomas wrote, "I join Justice Scalia's dissenting opinion. I write separately to note that the law before the court today is, quote, uncommonly silly. See Griswold versus Connecticut, 1965, in a dissent by Justice Potter Stewart. If I were a member of the Texas legislature, I would vote to repeal it. Punishing someone for expressing sexual preference through non-commercial consensual conduct with another adult does not appear to be a worthy way to expend valuable law enforcement resources. Notwithstanding this, I recognize that as a member of this court, I am not empowered to help petitioners and others similarly situated. My duty, rather, is to decide cases agreeably to the Constitution and the laws of the United States. And just like Justice Stewart, I can find neither in the Bill of Rights or any other part of the Constitution a general right of privacy, or as the court terms it today, the liberty of the person, both in its spatial and more transcendent dimensions." So Justice Thomas is making it quite clear that he thinks the law before the court, the Texas Sodomy Law, is an absolutely asinine piece of legislation. And if he were a member of the Texas legislature, he would vote to pull it off the books. All right? But he makes it clear also that he's not. He is a member of the Supreme Court, and he does not feel that the Supreme Court has the authority to strike this law down as it violates no general part of the United States Constitution. Notice that he references Justice Potter Stewart's dissent from the landmark Griswold versus Connecticut case decided nearly 40 years before Lawrence versus Texas, the case that established the landmark constitutional rights to privacy. Okay? So that's why I made the argument that Justice Thomas's dissent is almost like a touch of sympathy to the petitioners. You know, he thinks the law is stupid and would vote to repeal it, but his hands are tied because he's not a legislator. He's a Supreme Court justice. All right. So that takes us to the judgment of the court, which held that the judgment of the 14th Court of Appeals of Texas was reversed and remanded. The laws applied in this case were the 14th Amendment to the United States Constitution and Texas Penal Code, Section 2106A. So the legacy of Lawrence versus Texas, and I remember this case very vividly. I was 18 years old when it came down. You know, still a very, very wonderful decision. I feel the same way about it now as I did at the time of this recording almost 20 years ago. All right. Lawrence was a powerful foundation case for the protection of civil rights for gay and lesbian Americans. All right. In using the 14th Amendment's due process clause and equal protection clauses here, the Lawrence decision paved the way for future landmark decisions in gay rights law, including U.S. v. Windsor in 2013 and Oberfeld versus Hodges in 2015. In the states, Lawrence served as an inspiration against bans on same-sex marriage and a defense, okay, against them. All right. In Massachusetts, okay, the landmark decision Goodrich versus Department of Public Health, 2003, which legalized gay marriage in the Commonwealth, recognized a line from Lawrence in its opinion. It said, "Our obligation is to define the liberty of all, not to mandate our own moral code." By contrast, in several other states, including Arizona, Indiana, and New York, the scope of Lawrence was limited to affirm those locales' individual bans on same-sex marriage, as the groundwork laid by Lawrence did not cover a same-sex marriage, but Lawrence certainly provided the foundation for the inevitable legalization of same-sex marriage nationwide. So because of the far-reaching effects of Lawrence, it has often been referred to as the Brown versus Board of Education with respect to gay Americans. And that classification is a fitting comparison, as Brown v. Board of Education is often viewed as the the watershed case, you know, which opened the door for a litany of other Supreme Court decisions in the favor of African American civil rights, and also stimulated congressional action to enforce civil rights for African Americans, indeed all Americans, regardless of their race or color. All right. So Oberfeld v. Hodges, 2015, which legalized same-sex marriage nationwide, is arguably the most far-reaching progeny of Lawrence, okay, and is the boldest step to date that the Supreme Court of the United States has taken to protect gay equality under the law. So that is Lawrence versus Texas, okay, ladies and gentlemen, and for reference purposes, it is 539 U.S. 558 2003. Okay. And once again, before you leave, summary of the opinion. The Texas law, which criminalized the private sexual conduct of homosexual persons, infringing upon their rights to liberty and privacy, violated the Due Process Clause of the 14th Amendment to the U.S. Constitution. The controlling precedent, Bowers v. Hardwick, 1986, was therefore overruled. So thank you so much for listening to this history/law bite. If you have any questions or controversies, leave them down below. I'll be happy to answer them. If you like this video, gain some knowledge and insight from it, drop me a like on the video, please. It means more than you realize. And if you haven't subscribed to my YouTube channel yet, please do so now. Juarez Lee Shelton, M.A. Just click that little red subscribe button. It's free, costs you nothing, and you give your support and help me stay motivated to keep making these videos. So I'll conclude with the words and wisdom of one of my teaching role models, Mr. George Feeney. Believe in yourself, dream, try, do good. And with my own words, be blessed, stay safe, and take care of yourself out there. Cheers.